Good morning. I think we need to start. We will start with Mr. Victor Mabindula. Honorable Breitenbach.
Thank you, Honourable Chairperson. I'm sorry to interrupt the proceedings. I must draw to your...
Honorable Breitenbach, can you come closer to the mic if you can, please?
Sure. I want to draw to your attention, Mr. Chair, the fact that there are two people on the list, Mr. Shadrach Tibile and Ms. Bonachego Mokhaladi, who have some sort of connection with Ms. Mkhwebane. Mr. Tibile is acting pro bono for Ms. Mkhwebane in a matter, and Ms. Mokhaladi has worked and still works at the Public Protector's Office, was disciplined in the time that Ms. Mkhwebane was the Public Protector. Ms. Mkhwebane decided that the sanction should be dismissal. The matter was overturned in the Labour Court, and so she's still there. I see a clear conflict in both of those matters, an unavoidable and ineluctable conflict, and I believe that that conflict will place at risk this entire proceeding. And I'm sorry to only raise it now. I expected Ms. Mkhwebane to recuse herself of her own volition and send somebody else. But the fact of the matter is now she's here, and my concern is that the process will be tainted by that fact. You understand that the perception of bias is sufficient. Real bias is not the requirement. And there can be no doubt that there exists, there's an ineluctable conclusion to be drawn that at least a perception of bias exists. And so my concern is that the proceedings will be tainted, and I'm not sure that we can proceed constituted as we are now. Thank you.
Thank you very much. I must say that you have already raised the matter, and I have, before Honorable Mkhwebane responds, that we have asked the parliamentary legal advisors to come and assist us, but it will only be fair also to give Honorable Mkhwebane an opportunity. But we have been told that the legal advisors will be here in 30 minutes' time. But it will be important to give Honorable Mkhwebane an opportunity to say something. Is it a procedural point?
Yeah, maybe just one additional point, Chair, if you'll allow me. Honourable Breitenbach has spoken about a perception of bias, and that is most certainly one of the reasons why, in our view, there must be, well, we can call it a recusal, but what we really asked for is that the EFF just simply are represented by somebody else. But let me just add, before Ms. Mkhwebane then responds, to say that the ordinary rules around whether somebody should be allowed to be involved in appointment processes also turns very much on the relationship. And in the case of the first candidate, it's quite clear that because the candidate is acting in a pro bono manner, he firstly must believe in the case. So it's not as if you receive a brief which you really must then go and present to the best of your ability. If you agree to act pro bono, there is a, I want to say, a buy-in on your side. The second part is, however, that there's from that derived a clear benefit by Ms. Mkhwebane, because she doesn't have to pay fees. And in the circumstances, that in our submission would mean that even if she says that I can distance myself from that relationship for the purposes of these interviews and the recommendation, it's not as simple as it is. We must take we must take note of the fact that there's that relationship which is beneficial to Ms. Mkhwebane, and which in the circumstance, even if we all agree that she might be able to divorce herself of that relationship through this process, will render it fatally flawed. Thank you, Chair.
Thank you, Honorable Horn. Honorable Mkhwebane.
You know, I wonder why, and the DA, I will say that, would raise something like this at the beginning of the proceedings when I was going to declare. I think even in the last interviews of the Human Rights Commission, there were a number of candidates where one worked with very closely and others knew from the province where I come from, and there was a upfront declaration, well, which Breitenbach and Horn, Honorable Horn and Honorable Breitenbach, they failed to declare their relations to some of the candidates which we interviewed for the Human Rights Commission. But then coming back to Advocate Tibeila, indeed I was going to declare, and being an advocate and a legally qualified person who believes in the issue of objectivity, that is not going to influence the processes in any way, because what they fail to indicate is that their Honorable Milham in the Section 194 committee failed to declare, because you just declare. There was a matter in the Western Cape High Court which was appearing before one judge who had a personal relationship or knew the evidence leader, Advocate Bauer, and the person just informed us and indicated, do we have any issues for us or for her to hear the matter? And indeed, believing in the objectivity, or any person who's legally qualified, that you would be objective, you will focus only on the matter, on the merits of the matter. But secondly, Chairperson, I am not the key decision maker in this particular matter. I am part of the collective, and the question is the decision which will be taken today. It will depend on who the majority wants to appoint in this particular process. And secondly, Chairperson, the fact that Ms. Mkhaladi worked at the Office of the Public Protector, underwent the process, it's similar as you being the head of an institution interviewing an internal candidate. And that particular internal candidate, you'll know all their work ethics and processes, and you will ask accordingly to say, how would you deal with this situation when you are facing this? So I think it's just an unnecessary issue for them to raise this upfront, as if I am the decision maker. I will force myself that you must appoint Advocate Tibeila, or you must not appoint or appoint Ms. Mkhaladi. So I don't think, Chair, it's fair for them just to raise that. And I mean, as the economic freedom fighters, we would want to participate in this process, and might want to make sure that whoever is appointed is somebody who would work for the institution, but for the people of South Africa, and protect the people of South Africa. In case anything happens to the public protector, that person will be qualified, and everyone who is represented by us here in Parliament would know that a person we believe in and will protect the public is represented. So as you discussed earlier with me, and it is disingenuous for the DA to just raise this matter now, because they should have raised it during our deliberations, a short list, to say, but Advocate Mkhwebane, because, I mean, we work as a team here and as a collective. Now, why come back here and just raise this issue last minute? So I think it's very problematic, Chairperson. And I think we will have to make sure that whatever decision we take it objectively. We don't push our own agendas. we just focus on the people of South Africa. Thanks, Chairperson.
No, thank you very much, Honorable Mkhwebane. As I had already indicated, I think it will be important that this process is not tainted, and we try to be as objective as we can. That is why we have asked for somebody who is a legal advisor of Parliament to come and say what legally the position is, and after that we can proceed. We have two choices which I would like the guidance of the House on. The first one is that we take a risk of starting with the second person to be interviewed where there are no issues, as we are waiting for the legal advisors to come, or we don't start. We wait for the legal advisors to come to advise us on the process as a whole. With what has been raised, it's quite clear that we will have to revise our timelines. We might not finish at 5. We might finish late at night, depending on how soon the legal advisor comes and what is the advice that will be given to us. Then we can have a discussion now based on that legal advice, which we think would be objective, because that person is not part of us now. So we know that parliamentary legal advisors are not part of committees, but we always have respect for, in fact, we have respect for their legal opinions. Will that be fine, Honorable Ngola, Honorable Janchi, Honorable Ramulubeng, Honorable Jele, in that order?
No, thanks very much, and I think let's appreciate that this matter has been brought into our attention. Although one would have preferred that it is actually raised in the closed committee meeting, which started at 8:30. Now we're impeding on the time that we could have used for other purposes. But I think the directive you are giving is quite helping, in that we need to determine this thing very fast, but we need to be cautious of time as well. So I think it is very important that we start, if number 2 is ready, we can start with them, whilst legal services unit is attending to this matter, as you suggest. Then after having been given the legal advice from the Parliament legal unit, we are able to discuss and give a way forward as the committee then. Thank you very much.
Thank you very much, Honorable Chancho.
Lordship, without any waste of time, Honorable Ngola has covered me sufficiently at this point that we should immediately call in candidate number 2, go through that, and by the time we finish, we would have the legal advisor here, which would assist us with number 1 and number 3 in any case. And having listened to Honorable Breitenbach, Honorable Horn, and Adv Mkhwebane, then we reserve the committee deliberations after we have listened to the legal advice, and then we come in, so that we don't waste time in that regard. Thank you, Chair.
Thank you very much, Honorable Ramulubeng.
Thanks, Chair. I think I would echo the very same sentiments by Honorable Ngola and Janchi on us proceeding with the second candidate, because I also wanted to speak on the matters that are brought. So I'd agree with the suggestion that Honorable Janchi has made, that we wait for the legal rep of Parliament to come in, and after we've heard that, then as the committee we can deliberate on the matter. Because I also do agree that we should have used that 30 minutes that we had as the committee to also interrogate this matter if it was brought. So let's not waste time and proceed with candidate number 2. Thanks, Chair.
Honorable Jele, then Honorable Breitenbach.
I think I'm covered by the colleagues, but I only have a question. Thank you very much. I only have a question, Chair, that the advice that we're going to get from the legal advisor this morning, I want to find out that is it going to cover even, it will also give us the understanding of going forward in future. Because if you have to consider the life of Advocate Mkhwebane on these issues, so she has been involved with lots of people considering the kind of work that she was doing. I understand this one is in another level, but there will be lots of people that will be coming in this committee, in front of the committee, as we continue in future activities of the committee, and her being part of this committee. I want to just to find out that it will be the story of the future also. That because for me, just to declare and make everybody aware, like as we normally do, it also covers that. But as we say, we will hear also the advice. But now, that issue, it should also cover the future activities and the life of Advocate Mkhwebane as part of the committee. In terms of her having to, she's been working with a lot of people because of another life, her other life of work. Thank you, Chair. Just wanted to find out.
Thank you very much, Honorable President.
Thank you, Honourable Chair. I'm going to confine myself to the immediate issue today. Chair, I don't believe that it would be wise, and it's our submission that it's not wise, to proceed with any interviews until we've cleared up the matter. Because if there is a bias, if there is a perception of bias, and there must be under these circumstances, then that bias taints the entire process. Also, the interviews that follow, that are not concerning the two individuals already mentioned, because the bias spreads to everybody, not some for, some against. The bias exists. The process cannot proceed in the face of the bias. That's the problem. And I understand the issue, and I understand the time issue. And it really is a pity that we have to deal with this under these circumstances while people are waiting to be interviewed. But this process is a serious process, Chair, and a lot of money has been spent on it. And to have it set aside on the basis of something that we were aware of, that we could have dealt with, and we didn't, is going to be a problem. So it's our view that we should not proceed, Chair, until we've cleared up the matter. Thank you.
Honorable Jale, with respect to your question, I mean, whatever advice we get from the legal services, it forms part of the guidance, but facts are not always the same. But it does assist to, it serves as a point of reference continuously. So it's always important to, for that particular purpose. I think other than that, we'll be speculating. Maybe next time, Honorable Mkhwebane will be in the Portfolio Committee of Sports. So we don't know. Parliament is coming to an end. So I think let's just keep it that it's an important information that always guides committees. The legal opinions are filed to guide it's a procedural advice that is given on a particular matter, but any matter related to that, then even the next committee will make reference to that particular committee. Members, there are just these two views, but the majority feels that we can start with the second person. We have heard what Honorable Breitenbach is raising, which is a legal matter that the perception of bias can taint the whole process. I want to bring it to your attention that if members feel that we still continue, but we should know that that was raised.
Shall we move on? Huh?
Please raise your hand so that ungahlebi. So, members, do we proceed with the second one or we wait for the legal opinion? I think it must be clear that it's minuted. Honorable Janji?
No, Chair, I think I've listened to the last part of Honorable Breitenbach. He's raising a specific issue, and you can't have a specific issue that becomes a general issue. And so I would suggest that we proceed with number 2. We will come back when we deliberate and respond to all of those issues. Thank you, Chair.
Thank you. Honorable Mola?
Chair, I would say the reasonable possibility of bias is not COVID-19. Does not just get transmitted because people were seated in the same place. I mean, it's an unfair argument to say because of Mokhaladi and Tebeila, now everyone else must be included. The last we checked, when the matter was submitted to us, it specifically spoke about Mokhaladi and Tebeila. Hence, we even made submissions to the committee that let's rather take the second one so that we deal with this matter because the matter is specific to 2 candidates. Now, it's reasonable and fair to say now the entire process is tended with bias. We've got 8 candidates, Chair. So we need to proceed with the second candidate. Thank you.
Thank you very much. Okay, the majority of you says we need to proceed. But I think it will be fair, committee secretaries, to inform all the candidates that we will be running a little bit late, including the first one that is going to come in. We will apologize to him. Honorable Breitenbach, are you still on the same matter?
Thank you, Honourable Chair. We note the decision of the committee to proceed in the face of our advice that it's dangerous to do so and that the process is almost certainly going to be compromised. And that is the view of the Democratic Alliance. We will proceed in order to not disrupt the matter further. We do so under protest. And again, we repeat our advice that the process is going to be compromised. And we want that to be very clear, and we want the record to show that we have argued in the committee that the process is fatally flawed if we proceed. And we proceed here under protest.
I think the views of the Democratic Alliance as espoused by yourself will be noted and minuted.